Welcome to the class. Today in the series, let's talk about Introduction to Companies Act 2013. Okay, so the first video of the series deals with basic characteristics of company under Companies Act and general idea about what is a company all about. We are also dealing with important case laws in this aspect. Okay, ready then? Let's see. The term company is defined under Section 3(1) of the Companies Act 2013, which says a company is a company which is registered under this act or any other previous Companies Acts. That means it can be a company registered under this act, or it can be a company registered under 1956 Companies Act or any other previous Companies Acts. But at the same time, this definition does not give us an idea about what are the characteristics of a company. And therefore, generally, we follow the definition given by L.H. Haney about a company. According to him, a company is an incorporated association. A company is an artificial legal person. Company is an independent corporate personality. Companies are generally having limited liability, perpetual succession. It can hold and dispose of property. Its shares are transferable. It has a common seal and it can sue and be sued. Okay, I'll explain these points. A company is an incorporated association. It is a group of people coming together and registering themselves. As we all know, registered companies are the most popular form of companies, and therefore company is basically people coming together. But those people who are coming together, when they register themselves as a company, then the company comes into existence. Okay, so registration is compulsory in order to form a company. Okay, now a company once registered becomes an artificial legal person. Be careful, this is very important because see, you and me are legal persons. We are able to enter into contract provided we are 18 and we are having the capacity to enter into contract. We can enter into contract, we can sue and be sued, we can buy property, we can sell off property in our own name. Okay, so we can enjoy all proprietary rights as a natural person. Okay, now all these privileges are given to an artificial person, a person which is not natural, like a company. We are giving all these advantages of a natural person to a company, whereby a company is also like us, capable of entering into contract, holding property in its own name, buying property, selling property, going to the court, etc., etc., etc. So whatever natural person can legally do in the legal capacity, they can be done by a person which is created by law artificially. Company is an artificial legal person. That means the moment company comes into existence, it becomes another person. A company is a person. A company is having proprietary rights, but company is not a natural person. Okay. Yeah. And therefore, a company is having an independent corporate personality. What do you mean by that? A company is different from its members. A company is different from its promoters. A company is different from its directors. The moment it comes into existence, it becomes a third party, totally different from people who made the company all about. So company has an independent and distinct personality of its own. These are the significant features of a company form of organization. Okay, and in general, though there are companies in India, we can register companies with unlimited liability, but at the same time, generally, companies are having limited liability. The liability of the members is limited. In what way it is limited? It can be limited by shares, it can be limited by guarantee. That depends upon how you are forming a company. But in general, members' liability is limited. This is one of the major attractions of company form of organizations. Okay, yeah. Now, perpetual succession. Another attractive feature of company is this, that company is different from its members, and therefore even if all the members die, all the directors die, company will continue its existence by adding another member, by adding another director. See, company, they say, is like a river. Water may come and go, but the river remains. Similarly, members may come and go, but the company remains. Company is created by law, and you can kill a company only through a process of law, which is called winding up of a company. Okay? Yes. And as I told you, company is an artificial legal person, and therefore company can hold and dispose of property. Company's shares are transferable. This is another feature of company. Company's shares are transferable. See, there could be some difference between private company and a public company. There could be differences in the transferability of shares, but in general, company's shares are transferable from one person to another person, not like a partnership. Okay. Yeah. Now common seal. See, company is an artificial person. Company cannot breathe. Company cannot write. Company does not have hands or legs or brain or something. Isn't it? So how companies enter into contracts? They cannot, the company cannot sign, isn't it? So company is affixing its common seal. The common seal is considered as signature of the company. Wherever the common seal is affixed, it is considered that company has signed. Okay. Now the last one, a company can file a suit against other person. Other parties can file a suit against the company, not against the directors, not against the members. If you have any problem with the company, you can directly file a case against the company because company is a legal person. Okay, so these are the characteristics of a company. Remember, once again, company is an incorporated association. Company is an artificial legal person. Company has an independent corporate personality. Company's members' liability is limited. It has perpetual succession. It can hold and dispose of property. Its shares are transferable. It has a common seal which is considered as a signature, and it can sue and be sued. Okay, clear? Now let's discuss some important case laws in this area. Okay. Yeah. The first one, and maybe the most important and famous one, is Salomon versus Salomon, which was decided in 1897. See, it's a very old case law, but at the same time, still it holds water. So Salomon versus Salomon was a case where Salomon purchased Salomon Sole Trading Company. So Salomon Sole Trading Business. Okay. So Salomon's business was purchased by a company called Salomon Company Limited, and Salomon Company Limited had 7 members: Salomon, his wife, and his children. Okay. Now as Salomon Company Limited, it took loan from outsiders and continued doing the same business which otherwise Salomon was doing. But what happened? Within a year, company went into liquidation, and at the time of liquidation, see, when Salomon's business was purchased by the company gave £20,000 worth shares, equity shares, and £10,000 worth debentures of the company. Okay. Now, the company took loan from outsiders, which was coming all about £7,000. Okay. So, company's assets were only £6,000, but company's liabilities were 10,000 to secured creditor, that is debenture holder. Now, who is the debenture holder here? Salomon himself. Then outside creditors, £7,000. So, what happened? The entire asset went in paying off Salomon himself because he was the secured creditor. against which the unsecured creditors went to the court and claimed that Salomon and Salomon Company is not different. It is one and the same, and therefore he should not be allowed to fool the public in the name of a company. But in 1897, the court held that the basic principle of company law is this, that company is different from the members or directors. So it's not our business to look behind the company and identify people. Company has a separate personality. This rule was laid down in Salomon versus Salomon. Similarly, another case is there, Lee versus Lee in 1961. See, almost 100 years later. But still in this case, see, this Lee has formed an airways company. Lee had, out of 3,000 shares, Lee had 2,999 shares. Lee appointed himself as the managing director and the chief pilot of the company. While flying, there was an accident, and in air crash, Lee died, and therefore the company compensated his wife as a death of an employee during his service. Okay, so at that time it was held that there is no difference between the company and the person, but the court continued with its same stand that we need not look behind. As far as we are concerned, there is one company and there is a member. We need not inquire who is the member. We are going by the company's independent personality. Okay, so this rule laid down in Salomon versus Salomon was again reiterated in Lee versus Lee as well. Okay, now another case law is not regarding this. This is an Indian case law. State Trading Corporation versus CTO in 1963 held that company is not a natural person. Okay, I told you company is an artificial person. Company can enter into contract. Company can buy property, sell property. But at the same time, a company is not a citizen of the country. Company enjoys many rights, but it is not treated as a citizen under Citizenship Act. And therefore, it will not enjoy any rights as a citizen. Okay, so these are the major case laws in this regard. About the many other details of companies will come in, we will meet in another video. Till then, bye.